counsel.
May it please the court, I'm Ricardo Corona. I'm here on behalf of the plaintiffs and appellants, Jose and Anais Suarez. I'd like to reserve 2 minutes for rebuttal.
And would you either get closer to the microphone or speak more loud?
Yes, Your Honor.
Thank you.
We are here today because the trial court has dismissed Jose and Anais' claim for damages as a result of negligent security at the Benihana restaurant and has closed the door to the courthouse before they were able to go before the jury to present their claims. I think that a brief review of the facts would be in order, Your Honor, and if you may. Jose and Anais, together with their daughter, the 4-year-old daughter at the time, Siana, the mother-in-law, the aunt, the brother, and his girlfriend went to dinner at the Benihana in North Bay Village. They had an uneventful dinner, and they were waiting for their car in the valley outside the restaurant when they got into an argument and were subsequently attacked by 4 or 5 individuals. During the fight, which happened there in front of the restaurant, Jose was beaten, held by 2 people, was beaten very severely. He was bleeding. The 4-year-old went to his aid, was hit in the back of the head with a glass with such force that the glass broke, knocked it to the floor.
So what's the heart of your claim against Benihana? What did they do wrong?
That they provided no security, that they had a duty to care for these individuals who were business invitees of theirs, that they had a duty to protect them from these.
This was not a robbery or anything like that. It was just a personal disagreement, correct?
Well, it was not a robbery. It was no personal in the sense that there was no prior relationship between the attackers and the victims.
A verbal altercation happened, and it escalated to a physical altercation, correct?
That's
While
correct.
people were waiting for their cars.
That's
so
correct.
That's the nature of the suit against Benihana. But we're here because the action was dismissed as a sanction, correct?
That's correct,
Is that
Your
the
Honor.
point today? The point
That's
is
the point
whole
is that
lawsuit was thrown out as a sanction because your clients purportedly lied in their deposition or changed their stories in their depositions.
Well, that's exactly the point. The clients, Jose and Anais there was 2 legal actions here. There was a criminal case that was against the 3 assailants where they were charged with felony battery and child abuse charges. One of the defendants was dropped from the case. Their case was no pros. The other 2 were convicted and took
But
place.
the real point here is some depositions were given during that proceeding or close to that time, and then years later different depositions were given, and they didn't exactly match. It wasn't the sanction. Weren't your clients sanctioned because some material things supposedly changed?
Well, they were sanctioned, but that's not exactly right. On the case of Anais, her deposition in the criminal case, taken 6 months after the criminal case, and 4.5 years later, her deposition testimony never changed. There was no discrepancy in her testimony between her original deposition and her second deposition.
But she was thrown out along with Jose, correct?
She was thrown out along with Jose.
So the problem was with Jose's deposition.
Well, in Jose's deposition, there was some minute discrepancies in his testimony regarding.
And your position is that the remedy was far in excess of the damage or the wrong, if any, and that this was as they say incorrectly in the cases, this is the death penalty of civil litigation, and it wasn't justified by what happened.
That's correct, Your Honor. And the types of discrepancies in the facts that came out are not relevant or material to the claim, the basic claim that they're making.
You say they don't go to the heart of the claim.
That's correct.
They may be, did I have a drink or did I not have a drink?
Exactly.
Did I use a curse word or did I not use a curse word?
That's correct, Your
Was I
Honor.
hit on the side of my head or the front of these kinds of things, which have nothing to do about the claim itself, which is, did Benihana provide?
That's correct, Your Honor. And not only that, I think they're very forthright that any study or any review of both depositions will show that they were very forthright in their testimony at the time that they gave them. They gave extensive testimony regarding their medical injuries.
Well, that's not really, the real issue is whether the discrepancies go to the heart of the case and so undermine the justice system because there's such a change that no justice can be done other than throwing this whole case out. Isn't that what the case law says justifies dismissal? And your argument is that isn't what happened here?
That isn't what happened here. The factual disputes are not, don't raise to the level of that's required under the case law. Also that the judge actually applied the wrong law to the facts, and that she relied on the criminal statutes regarding perjury, and found, since there's a criminal statute that says if you, in a legal proceeding, give a conflicting answers in two depositions, that's a perjury. And since she found that he had said that he had not had a drink in the second deposition, he said that he had one drink in the first deposition, used that as an example of different testimony, and found that that was perjury. And since that was perjury, she then jumped to the conclusion that she was required to dismiss the case because there was some kind of fraud on the court. Our position is that there was nothing that was material in any of those depositions. There was a lot of testimony. There's nothing that went to the issues of whether location, even though there's some talk about whether they were offered to fight across the street or not, that the actual location of the incident happened right there on the premises of Benihana. The alcohol regarding the issue whether he had one drink or not is inconsequential as whether he had a steak or a fish for dinner that night in the restaurant, and doesn't go to any of the hearts of the plaintiff.
Let me ask you a question. How do you distinguish a case from our district, such as Ovehi at 644 Southern 2nd 550, where we affirmed the court's dismissal of a personal injury case, where the trial court determined that there were repeated lies under oath concerning the plaintiff's personal background and education. These were tangential issues. They did not go to the heart of the issue of liability, and we found no abuse of discretion in the court's drastic remedy of dismissal based upon the repeated lies that were uncovered by the defense.
I think that the Ovehi case, along with another case I don't recall the name on, is that not only does it go where the lies in the case law really says that either it goes to a material issue or the lies are of such a magnitude that interferes with the ability of the defendant to defend this case.
The court in that case wisely said.
Yes, it was extraordinarily wise.
This man lied about where he went to school, or I think he tried to get away with saying that he had gone to St. Thomas, but actually he had gone to the University of Miami. Who could blame him? On the other hand, he deliberately lied about what his background was, and therefore what the damages would have been to what had happened. And this was not a mistake about what side of the street they were on. This is a deliberate lie about that he was a PhD when he hadn't gone to secondary school. And this is something that you cannot, the system of justice, and there was a dissent, I believe, the system of justice could not tolerate. This is not this case.
Did that answer your question?
Yes, thank you very much for your answer to that question. Well done.
In the case, really, anyone who read, I think that the judge was kind of hoodwinked by the defense with their chart that they provided to her, that she incorporated into her order. Any review, I think, of all four depositions that you look at, the gist and the basic facts are the same. The whole incident is portrayed. There's some minute differences. There's some question. The first deposition, as a matter of fact, was handled by two separate attorneys, which were representing each of the co-defendants, and that whole deposition took a whole half hour to
But
take
counsel,
place.
the truth is the truth is the truth, and it doesn't matter how many lawyers you have or who's representing whom. If it gets to the real nub of the issue, you're under oath.
The question is, how bad is it? Is it bad? Is it very bad? It's got to be very, very bad in order to justify this result.
Absolutely.
And your argument is it wasn't even very bad. It wasn't even bad.
It wasn't even bad. In Anais' case, it's even more offensive, I think, Your Honor, because she did absolutely nothing different. And she sat, the only question they're saying is that she sat through a 4.5-hour deposition of her husband, 8 days before her deposition, she was asked, was there anything that, she wasn't told that she was going to be tested on, his accuracy later on. She was asked, was there anything that he said that you have issues with? And she said, well, he got the birth dates wrong on the kids' birthdays, which is
What would you suggest the remedy should have been by the trial court? Since you're asking us to reverse and find that it was an abuse of discretion to dismiss, what do you think the trial court judge could or should have done that would not have amounted to an abuse of discretion in a case like
I really think, Judge, first of all, there's with regard to sanctions, monetary sanctions, I don't think there's any, because
I'm not limiting you to monetary sanctions. I'm asking you, what do you think a trial court faced with a prospect of diametrically opposed portions of two depositions regarding the same incident that in at least to some extent cannot be reconciled? What do you think a trial court judge could have done in this situation that would not have amounted to an abuse of discretion but still would have carried out a sanction?
I think the judges in the trial division deal with these issues every day, and they're used in as impeachment material. If there was any cost involved,
the remedy is to send it to the jury to resolve.
That is correct, Your Honor. These are the types of issues that's what the trials are all about, that there's factual
And
disputes.
if the jury doesn't believe one of the plaintiffs and they find for the defendants, the plaintiffs have suffered maybe not the death penalty, but it's life imprisonment without possibility of parole so far as this case is concerned.
That's correct, Your Honor. And in this case, there was multiple surgeries to the
Counsel,
Anais.
I'm going to cut you off because I've let you go over time. They'll still give you 2 minutes for rebuttal.
Thank you.
Hear from opposing counsel.
Yeah, good morning, Your Honors. Michael Shelley and Greg Lasser on behalf of the defendant, Appellants, Benihana. I think the most recent question about what the appropriate remedy would be if the trial court had not entered the sanction of dismissals.
Why did the court, is this an appropriate remedy? To dismiss an action, to completely throw a lawsuit out of for the kind of purportedly improper behavior that was at issue here? Why was that an appropriate remedy here?
It's an appropriate remedy because the courts have given trial court judges the authority and the responsibility to enter appropriate sanctions.
Counsel, we all know what
we all know what the standard
what
is.
the principles are. The issue is that they do something terrible, so terrible as to justify throwing the case out.
Okay.
What's the closest case you have which sustains such a remedy on such a record?
And certainly, Your Honor, and both of you have faced multiple occasions. I would say that
preferably it would be one decided by me. Ordinarily, it would be one decided by the chief judge.
Well,
give us one. That's the worst. Even Judge Evis.
well, let me give you the Leroy case.
What?
The Leroy. Laurore, which both of you were involved in back in 2009.
What did the plaintiffs do?
In that case, the trial court, the entire case, because the plaintiff had admitted information regarding his employment and lost earnings. It was a damages claim.
It was a deliberate. They were deliberate lies. In that case, as I recall, he had said he wasn't able to work. He had applied for unemployment.
Exactly.
Like that.
Exactly.
Is that
Yeah.
it? Well, that wasn't deliberate. These are mistakes.
Well,
at best, is that the best case you have?
I would say that case is.
Is that the best case you have?
Your Honor, I think the best case that we have is the Leo Skelf liquor case,
That was repeated lies, absolute lies.
In depositions, by 2
What
plaintiffs.
are the lies in this case you think? I'd like you to pick two lies.
Mm-hmm.
I'm going to call them lies for your benefit, that you think go to the heart of the matter such that the plaintiff's conduct constitutes an abuse of the process or calls into question the very integrity of the judicial process that demands a dismissal by the trial court or demands that we affirm as not an abuse of discretion a dismissal.
Yeah.
The two worst.
The two worst is the provocation, criminal deposition. Jose Suarez explained that he had provoked his alleged assailants.
Where does he say in his criminal deposition he provoked it?
using the language, by using the
Tell me-
racial epithets, profanity.
So he said in the criminal deposition that he used profanity, okay?
Yes.
And he said in the civil deposition he never used profanity.
Correct.
Okay.
And also the fact that criminal deposition,
Was
testified that he was,
he asked, did you use profanity?
yes, he was.
The answer was?
He was asked, did you use that racial epithet? Did you use other profanity? With deference to this tribunal, I'm not going to use the exact language. He asked specifically, did you use that language? And
He had said the
categorically denied it.
N-word in his criminal deposition.
Yes.
And he was specifically asked in his civil deposition if he ever used the N-word. He said, no, I never did.
Correct.
Okay, a direct contradiction. No way around it.
Yes.
He's telling the truth in one and not telling the truth in the other.
Yes, sir.
That's true.
Yes.
What's the second lie that claim justifies a dismissal?
I would,
in
say the fact that it went from a verbal altercation into a physical altercation.
Well, they knew that, didn't they?
Excuse me?
Didn't everybody know that?
Yes, but in the prior.
Nobody would have been in court in either the civil or the criminal division if that had not happened.
But he denied using any physical touching with his assailants in the civil
This means that every
deposition.
time a defendant denies running the red light and the jury finds he did run the red light, you throw the case out.
Well,
It's up to the jury to decide what happened.
the primary issue here against Benihana was liability. That is the ultimate issue here. And the plaintiffs alleged in the complaint that Benihana created the dangerous condition that allegedly resulted in the injuries to the plaintiffs. Themselves, and particularly Jose Suarez, created the dangerous condition. And
By
that's
doing what?
Terrific jury argument.
By doing what?
with the language and provoking the aggressors that
But he did,
by
at
being the
what-
physical aggressor.
At what time he denied it? It's up to the jury to decide when he's telling the truth.
It's great impeachment.
Okay, in
I mean, you're
impeachment.
gonna mop the floor with these people at the trial.
Well, I appreciate your confidence, Judge, but there is.
You know, I'm not sure I'm confident.
Well, I think that
That's what you're arguing.
Yeah.
You're arguing, and what you rely upon are terrific jury arguments. But by definition, we have juries to resolve those arguments.
But are Your Honors suggesting that Judge Buchko in the trial court, that her decision was arbitrary
You know,
or
if it were
capricious or
even-
whimsical?
If it were even Judge Schwartz in the trial court. when
Well,
the-
actually,
the
especially if it was Judge Schwartz in the trial court.
The identity of the judge has nothing whatsoever to do with the case.
I
Either
understand.
the judge is correct, or what are we here for?
Exactly, and this is an abuse of discretion standard. So where
Swimming upstream against the principle that we'd like to have these cases disposed of on their merits.
True, there's that balancing
And
test.
these are very strictly discerned cases, because it is the death penalty for a case, and that's why these cases rarely pass muster where they're dismissed for this kind of thing. It's usually the kind of case where, I was in a rear end accident and it hurt my back, and the answer to the interrogatory is, have you had any prior back injuries? And the answer 42 times is never, and it turns out there's been 6 surgeries on the back.
And all three of us have dissented
Or
from affirmances of dismissals on the ground that's too big, it's too serious.
This would mean that every case, personal injury case, where the defense hires an investigator to follow the plaintiff around to show that contrary to the deposition he gave, where he says he can't lift anything, the video that your investigator took shows that he's out bowling in his team league every Tuesday, and then going and working for 2 guys moving in storage every Saturday, warrants on its own, without anything else, dismissal of the case. Without anything else. Not impeachment at trial, not ripping him apart on cross-examination, dismissal because it calls into question the very integrity of our judicial process, right?
Exactly, and I think that the courts are moving away from that the pendulum is swung away from that, because that is different than sworn testimony under oath. You basically have the deposition testimony or the interrogatory answers that are contradicted by surveillance. Here, this is a unique case in the state, and I'm sure that Your Honors appreciate that.
You know why?
Because we've got sworn deposition testimony that is so materially contradictory
I
to
thought
prior
that-
sworn
I thought
testimony
that
of the
was
plaintiffs.
A rhetorical question is a question to which you know the answer. But you were giving an answer that I didn't know. The answer that I know was that nobody previously has had the chutzpah to argue what you have done.
Can you tell me whether you think that this same argument applies with the same effectiveness to Anais' claim? And if so, how it can possibly be the same to someone who simply says, yeah, I heard what my husband said in depo, everything he said is correct?
Well, I think what distinguishes Jose's case from Anais' case is the fact that Jose himself was the aggressor. I mean, I think that his criminal deposition testimony...
We're not deciding who did what, whether he was the aggressor or not. We are deciding whether what he did in the course of prosecuting his case was so terrible and disruptive of the justice system as to deny him the right to use the justice system.
And it goes back to the basic elementary question here is, did they lie under oath?
Yeah.
Did Jose Suarez lie under oath, and did Anais Suarez lie under oath?
Do you mean to tell me that every time that a judge finds that a litigant has lied under oath, he or she has the authority to strike his pleadings if he's a defendant or dismiss the case if he's a plaintiff?
If they go to the heart of the case. And the heart of the case here is liability.
That little qualifier is a big qualifier, and it's an important one. If it strikes at the very heart of the case of the justice system, then that's a pretty heavy burden. It's a pretty high burden.
Exactly. And I think here the trial court was reasonable, made a reasonable determination that the way
Well,
they...
that's you're answering the question.
But they portrayed themselves as pacifists in the civil depositions, and that clearly was contradictory to the way they had previously testified in the criminal
have
cases.
you ever known, would there be a lawsuit? Has there ever been a lawsuit in which one party is not contradicted by the other party?
They've contradicted
Therefore,
themselves.
one or the other one has to be telling
Can
the
I ask
truth.
you a question? Because I want to go back to Anais for a moment, because I think we're giving short shrift to the stark differences between the two. In the judge's finding of facts, she specifically says the court finds that the defendant has demonstrated by clear and convincing evidence that the plaintiffs jointly and collusively engaged in a scheme designed to prevent the trial from impartially adjudicating this matter through lies. Will you tell me what evidence supports that finding of fact? What evidence in the record supports a collusive scheme jointly hatched by the two plaintiffs?
Okay, looking at the totality of the circumstances, Anais had the benefit of sitting through the entirety of her husband's deposition. She said the only thing that Jose said that was incorrect was regarding the birthdays. Now, in her deposition, she says, Jose said, we're with our family, we don't want any problems. That's what he said to his assailants.
That quotation doesn't come from the record.
I'm sorry, Your Honor?
That quotation doesn't come from the record. It happens to come from a case. And they only changed collusive from sententious, which is what Judge Nesbitt said in the case. That finding was so obviously planted in order to attempt to secure an affirmance on the basis of a previous case that it's not worthy of regard.
And I appreciate that, Your Honor. I would like to finish answering the question, though.
And then, counsel, you've used up your time, so finish answering the question and we'll move on.
The scheme was, obviously they're seeking monetary compensation here. She echoed what her husband had said in terms of being a pacifist and not provoking the fight. And she was a witness.
Concocted a scheme to get into a fight in Benihana?
No, I'm not suggesting that, Your Honor, but what I'm suggesting is now that they have a lawsuit for compensation against
They want
the
to make it
defendant.
a good lawsuit.
Exactly, and I think the trial court is allowed, under the standard, under Canicaris, under Mercer, under the prevailing abuse of discretion standard.
That's an abuse of discretion issue.
But it is, did the trial court make a reasonable determination based on the evidence before it? And the evidence
Under
here...
Under the law.
The evidence were the deposition testimonies in both cases, but the plaintiffs didn't offer any affidavits, didn't offer an errata sheet.
Would you agree materiality is a question of law that we can review de novo? The
Yes.
issue of materiality.
Yes,
So
I
if we were to find, for example, that while her other findings may be correct, that there were lies, that he lied in one of his depositions. If we were to find as a matter of law, though, that this is not material, then we would no longer be bound by a standard of review of abuse of discretion. It would be de novo in that determination.
Yeah, I would agree with that, Your Honor.
Even in the case that Judge Evis so correctly cited earlier, the footnote says if he had lost a leg in this accident, and everybody agreed a loss of leg, it might be, well, a loss of due process in order to deprive him of a claim for loss of a leg because he lied about where he went to school.
Exactly, but in the decision in Leroy where Your Honors reversed the dismissal and sent it back, suggesting to the trial court, look, he may have lied about his wage loss claim, but he certainly didn't lie about the extent of his physical injuries. So if you're going to do anything here as a sanction, go ahead and take away his wage loss claim, but allow him to pursue his other claims. The reason why I've tried to make the distinction here with this case...
And in conclusion, counsel, you would ask us to...
affirm the ruling of the trial court based on the fact that it was a reasonable decision based on the evidence. But if you allow me to...
Counsel, that question was a clue that your time is up, and in conclusion, you would ask us to affirm. Thank you, counsel.
Thank you.
Counsel, 2 minutes.
Mr. Corona, can I ask you a question?
Yes, Your Honor.
If we were to send this back and suggest that the court find some alternative sanction, could the court, for example, impose a stipulation that what your client said in his criminal deposition is taken as evidentiary fact? For example, would that be a sanction that might be appropriate, commensurate with the offense? That what he said in his deposition constitutes an evidentiary fact that cannot be contradicted?